वसीयत. Now I hope you all know what is the meaning of wasiyat. Wasiyat basically means will. That means a person, when I will discuss section 2 clause H of the Indian Succession Act also with you. Wasiyat basically talks about an instrument which you think will take effect on your death. That means whatever you want to happen with your property, whatever you want that your property should go to this and this person, that is known as wasiyat. I hope you all know that a will can be made at any point of time in the lifetime of an individual. Let us say a will is made here and the person dies. Upon the death of this person, immediately the very next second, the will becomes operative. Whether you get the property, whether the property is given at that time, whether there is a court case for the next 50 years, we are not bothered. But the moment the person dies, the property cannot be left res nullius, that means ownerless, and immediately the will is going to take effect. Will can be made multiple times by an individual, but always remember the last will which is made before the death will always be considered to be the valid and operative will. This is a rule of the Indian Succession Act. You need not study the Indian Succession Act. ठीक है, पंजाब में कभी कभार प्रीलिम्स में क्वेश्चन पूछ लेते हैं, उसके लिए मतलब आपको पढ़ने की जरूरत नहीं है, बट वो 2-4-5 एग्जामिनेशन में कभी एक क्वेश्चन आता है, वो गलती से ही आ जाता है. ठीक है. So basically what we are trying to say is will can be made multiple times also by a testator, and ultimately the last will be considered to be the operative one. The person who makes the will, that means whose property is being given, is called testator or legator, and the person to whom the property is given is called testatee or legatee. Fine. Person who makes the will, testator or legator, and the person who receives the property through will is testatee or legatee, and the property, the corpus of the property itself is called as legacy. Legacy या bequeathed property. Legacy or bequeathed property. The property which goes is known as legacy or bequeathed property. Now I have earlier told you that in Muslim personal law there are a lot of deductions that need to be made, right? For example, first is the funeral expenditure. Whatever is the funeral expenses, they will have to be deducted. After the funeral expenses, it is the unpaid salary. Then it can be the secured creditors. Then you have the unsecured creditors. Then what? Will. Then can be no. Then is will. Then last में the property left can go for inheritance. This is generally the sequence that is followed in Muslim personal law. If you remember, डावर के टाइम पे पढ़ाया था मैंने ये. जहां तक ये will की बात आती है, will के लिए the maximum property that can be bequeathed through will is 1/3 of your total property. That means if let us say the total property is worth 9 lakh rupees, the bequeathable property is only 3 lakh rupees. The bequeathable property will only be 3 lakh rupees if the total property is 9 lakhs. It is 1/3 of your total property that can go through will. Acha, who can be a testator? Testator has to be 18 years of age. Testator can be male, female, both. Testator has to be a Muslim, and testator has to be of sound mind. Remember one more thing, that minor can make a will, but he has to ratify on attaining majority. The minor can make a will, but the minor will have to ratify the will once he attains majority. तो minor भी will बना सकता है, but he will have to ratify. And what will be the age of majority? 18 years, because the age of puberty is only for marriage, divorce and dower. That is the age of puberty which is taken as the age of majority under Muslim personal law. Rest, for all matters, the age of majority is 18 years. Fine? Are we clear? Any questions, any doubts, any problems till now? Who can be a testatee or legatee? Any person of any faith or religion can be a testatee or legatee. You need not be a Muslim. You may be a Hindu, you may be a Christian, you may be a Parsi, you may be a Jew, does not matter. You may be a minor, you may be unsound, you may be major, you may be old, you may be sick. Does not matter. Any person of any faith or religion can be a testatee or a legatee. That means you can give your property to any person of any faith.